Hey y'all, what's poppin'? We have some major changes here at this podcast. We changed our name to The Legal Tea because this is your one-stop shop for what's going on in pop culture from a legal view. This means that we have changed or expanded the subjects that we're going to cover on the podcast to include more areas of law while still using real-world examples to break them down. We have a good one for you today, so let's get started. If you follow our Facebook business page, then you might recall a few months ago when I did a story about New Edition. I told y'all that Johnny Gill and Ralph Transman of New Edition have filed a trademark and received a trademark for the group stage name. And for those of y'all who missed it, here's the gist of the conversation.
Well, New Edition, everybody, well, I say everybody, everyone in my generation knows New Edition, the amazing boy group from the 80s, and they go on some ups and downs, members leaving, members coming, and new members and things of that nature. Well, recently, and I say recently because they've been out since the 80s, so in 2013, Johnny Gill and Ralph Transman, they actually applied for and registered successfully a trademark for New Edition. The name New Edition, the group's name New Edition, although they are not the only members of the New Edition group. Let me see, and they did that. The registration was successfully registered on October 29, 2013. And because of this, so now there's conflict amongst the members of the group. They want to go on tour. They have this trademark that they're not willing to add the other members as owners. So let's talk about trademarks and owners and why that and what that means. And so the one thing I tell you about trademarks, and maybe I should start, if you're new to Off the Mark and haven't seen me before, let me talk about trademarks really quick. So you have to remember that trademarks indicate the source of a good or a service. That means when someone sees this trademark, they know what they're going to get, what to expect, who it's coming from. So with that being said, trademarks are actually assets. People oftentimes forget that trademarks are assets. It's easy to see something. I'm just looking around to see. So let's say you have a business, right, and you buy equipment for your business. Say you buy an iPad or a computer for the business, right? You know that's business property. Or let's make it even something more tangible. A building. Let's say you buy a building and you buy that building for the business. Well, there's no question whether or not that building is personal property or a business asset because you bought that building for the company. Let's say you have a manufacturing warehouse and you buy all this manufacturing equipment. All those are assets for the company. But with trademarks, because they're not tangible, I think sometimes people forget that they're actually business assets. And so if this is for the business, then the business owns it. What you want to make sure that when you're doing your application, you want to make sure you have the rightful owner. So some people say, well, I came up with the name, well, that means that I should own the trademark. No, that's not how that works. So just like if you were working in a group or a partnership with someone, right? And one person put in $50,000, and one person put in $20,000, and one person put in $10,000. The person that put in the most money, depending on your agreement, will probably have more of the controlling say, or can get more of the profits at the end because they contributed more. So your trademarks, you had to determine what value, if you did come up with the name by yourself, like outside of this business group. Maybe you had this name by yourself, and then you came in with the group, and you said, okay, this is the name of the project that I was thinking of. You need to put a value on that asset. So here's the challenge. If you don't properly identify the owner of the trademark, your trademark application could be void. And so void means that it's like you never applied for it, meaning that if there was ever any type of trademark infringement and things of that nature, you wouldn't be able to stand on the grounds that you have a trademark registration because it's like you never had one. And so that's one of the things that I'm looking for in this case. What I've noticed that this was filed in 2013. After five years, there's a period of incontestability, meaning that trademark be very difficult to overturn that trademark. And so they're coming up on that 5-year mark. And I've noticed that there's been no type of action, no type of formal action with the USPTO to cancel the mark. And so I think they're in negotiations, personal negotiations. I'm interested to watch the outcome of this. I don't know how those two just decided to become the owners. I don't know if it's because there has been so much movement in the group and they have been there, but everyone has kind of gone their own way and had their solo career. So I don't know how just two people decided that they would be the owners of the new edition. Like, I asked a question that I cannot answer.
Well, in May, Ronnie, Ricky, Bobby, and Mike filed to cancel their trademark. Cancellation occurs after the trademark application has been approved for registration. Although trademarks are published to the public prior to final approval, many businesses, they miss the opportunity to object to the registering of a conflicting mark because they're not monitoring their mark. And when that happens, then instead of objecting to the mark, you have to cancel. If you cancel within 5 years of your registration, you can use any of the following reasons to cancel your mark. The mark might be confusing with your property or business. You're using the trademark before the registered owner. The mark is someone's last name, is descriptive or basic level, or describes a location like a country or city. It's deceptive in some way. Maybe the mark was not being used before registration, or you can prove that the owner never intended to use the mark in the first place. The mark hasn't been used or defended in at least 3 years. The registration was fraudulent. The mark dilutes the usefulness or the trade identity of another mark. There were major errors in the initial filing of the existing mark, and then after 5 years, it gets a little more difficult to challenge cancellation. So you can do it because the mark became so common that it's generic, or it defines the functional use, or the mark has become legally abandoned by the owner. Maybe it was registered in a fraudulent manner. The trademark is immoral or descriptive or scandalous. That's the reason that the Washington Redskin trademark was actually petitioned for cancellation. Maybe the mark is disparaging or suggests a false connection with people, beliefs, national symbols, or origins. The registrant either does not control or cannot control the mark. The owner of the certification mark produces or markets to goods or service to which the mark applies. The owner allows the mark to be used incorrectly. The registrant will not certify the goods or services to be maintained, the mark's condition standards, or the trademark was never published under the provisions of the Federal Trademark Act. Cancellation is a very important tool for business owners looking to protect their brand if they feel that their marks might be weakened by the other mark's existence, or the existence of the mark interferes with that business' ability to fairly compete, or if that mark will hurt that business reputation or operations in some type of way. Businesses are not the only people that can petition to cancel a mark. The Federal Trade Commission can actually apply to have that trademark canceled or revoked as well. Well, Ricky, Ronnie, Bobby, and Mike filed cancellation based on 2 reasons. 1, Johnny and Ralph were not the true owners of the mark, which will void an application. 2, fraud. Each trademark application is a sworn declaration that must be signed before the application is submitted. An authorized person must swear under perjury law that 1, he is authorized to execute the form on behalf of the applicant. 2, he believes that the applicant to be the owner of the trademark or service mark and sought to be registered. And 3, that to the best of the declarant's knowledge and belief that no other person, firm, corporation, or association has the right to use this mark in commerce, either in the identical form or thereof in such a near or resemblance. So basically in the same or similar mark. So the left out members of the group claim that the declarant was aware of their interest in the trademark and the fact that he used the application he used the group's start date on the application. He used December 12, 1978, which when the new edition as a whole first started. And then their proof of use was include a picture of Bobby Brown, his name, and his face. So they said with that, then you have to know that we should be included in this application. So our 3 top takeaways from this application are, if you're a business owner, your trademark is an asset, and that asset is owned by the business. Okay? So you must put that down on your trademark application. 2, if you lie in your application is going to be void. And if it's void, then it's like it was never filed. 3, you have to stay on top of your mark. That's part of defending the mark. I talked about previously that registration is only the first step. In order to make that registration and that investment in that registration worthwhile, you have to defend your mark. The only way to defend your mark is to know what's out there, and the only way to know what's out there is to monitor your mark. So you must do that. And if you if you miss it and you miss the chance to object, then you need to make sure that you file a cancellation within 5 years, because if not, it gets more difficult. So for Ronnie, Ricky, Bobby, and Mike, one of the things that they want to talk about real quick, and we talked about it in the one I did in February, or I think that's when it was earlier, a few months ago, or more than a few months ago, is that the application didn't have the true owners on there. Okay, and we talked about that. You have to have your true owners on there in order for the application not to be void. And I see this a lot of times with people who are getting ready to form an LLC. They will make the LLC the owner of the trademark, even though the LLC has not been formed, because they intend to file the application. They intend to form the business. But if you file the trademark with your LLC prior to forming the LLC, then the application is void, because the LLC did not exist at the time your application was filed. Okay, that is what we have today. That is our podcast today. Thank you so much for joining us. If you learned something today, you already know what to do. Hit the like button, hit the share button, give us a review. We have a Facebook page. We created for the podcast. It's called The Legal Tea. And we also created a brand new YouTube channel, also called The Legal Tea. So you can find us 2 places on YouTube, which is one, Beyond the Launch, where we will continue to talk about and answer your questions relating to trademarks, copyrights, patents, and business developments. And then 2, we have a page dedicated strictly and specifically for the legal tea, so that we can come over here and give you all this tea that's going on in pop culture, so you can understand and get the real understanding of what's going on and what these different legal battles really mean. Okay? That's all I have for now. Talk to you later.